I want to tell you about a family I met a few years ago because their story could easily be yours, and it has everything to do with avoiding a painful guardianship battle. So I'm going to tell you a little bit about what happened. Let's call them Maria and James. They were in their late 40s, living here in Florida, raising two kids, 12 and 15, and also helping care for James's mom, who has early stage Alzheimer's. Life was busy, and like many parents, they thought, we'll get around to estate planning later. Then one day, Maria was in a car accident. She survived, but her injuries left her temporarily unavailable to manage her own finances or make medical decisions. That's when the real problem began. Because Maria hadn't set up any planning documents, James couldn't automatically step in to handle everything for her. The bank accounts were in her name, and some investments were in her name alone. And that hospital wouldn't take his direction without proper legal authority. So what was the only option? A formal guardianship process through the court, which means lawyers, court fees, hearings, delay, during a time that they were already under immense stress. And remember, this was for a married couple who had always handled life together. The law didn't assume that just because you're family, you automatically have the right to act. This may be in certain scenarios, but when it deals with finances and money and assets, this is not going to work. When Maria recovered, they came to me determined to make sure they would never face that situation again. So what did we do? We created durable powers of attorney so each could handle finances for the other if needed, and also a healthcare surrogate designation, so medical decisions could be made without court intervention, and a living will to spell out their wishes in advance. And for their kids, we added preneed guardian designations. So if something happened to both of them, the court knew exactly who they wanted to care for their children. No guessing, no fights, no uncertainty. So if Maria and James hadn't taken these steps, they would have left the door open for more guardianship battles in the future, not only between each other, but also over who would care for their kids or James's mom if something happened to him. Instead, they now have complete legal clarity and protection, all with documents that took just a few weeks to prepare. So what's the lesson to be learned here? Make sure you don't wait for tragedy or something terrible to strike. Be prepared. You will be thankful that you did.